start. Good afternoon, everyone, and welcome to this webinar on the Scottish Sentencing Council's new Sentencing Young People Guideline. I'm Fiona Dyer. I'm Director of the Children and Young People Centre for Justice, or CYCJ as we are known. And for those who don't know us, we work to ensure that Scotland's approach to children and young people in conflict with the law is rights respecting, contributing to better outcomes for our children, young people and communities. And we do that by three main strands of work: through our research, through our practice support, and through our engagement and work with participation of young people who have experience of our justice systems. And we are delighted to be co-hosting today's event with the Scottish Sentencing Council, the aim of which is to explore the guideline's key themes ahead of it coming into effect into all Scottish courts on the 26th of January. The number of people who have signed up for today's webinar is testament to the level of interest in this subject, and we're grateful to everyone who has joined us. We at CYCJ have followed the development of the Sentencing Young People Guideline very closely. Lady Doran, the Lord Justice Clerk and the Chair of the Council, delivered a keynote speech at the National Youth Justice Conference in 2019, and the Council also held a workshop last year at the conference. And we welcome the guideline as a positive step in relation to the treatment of children and young people in our adult courts. And I, like all of you, am very interested in hearing more about some of the things that informed its development and of our three key expert speakers today. Before I hand you over to our host, John Scott QC, just have the job of setting out a few housekeeping rules. At the close of the presentation, we will have a chance for some question and answers. Due to the number of attendees, I think the best way would be to put your answers in the Q&A box that you'll see at the bottom of your screen. However, if you would like to ask a question, please do click the raise hand function to allow us to unmute you. Please only use the chat bar for general comments, as we won't be monitoring that for questions. We will post some links to key documents, including the guideline itself, in the chat bar, which you may wish to open and refer to. Finally, today's webinar, apart from the Q&A, is going to be recorded, and we will share that online after the event. Now, with that out the way, I'd like to introduce you to your chair today, John Scott, who I'm sure some of you will already be familiar with. A court lawyer for over 30 years, John has been a QC since 2011. He has been instructed in some of the most significant, complex and high-profile cases of recent times, and some of these including human rights cases at the UK Supreme Court. And he has presented arguments which have helped develop our law today. Amongst other things, he is the chair of the Scottish Human Rights Centre from 1997 to 2005, convener of Howard League for Penal Reform in Scotland from 2006 to 2018, chair of the Justice Scotland from 2014 to 15, and he is currently president of the Society of Solicitor Advocates and is chairing a major review of the mental health legislation in Scotland. John was the Scottish Sentencing Council solicitor member between 2015 to 18, and since then he's remained as an advisor to its Sentencing Young People Committee. He has therefore been heavily involved in the development of the Sentencing Young People Guideline from the offset. So it's my pleasure to hand over today John Scott QC. Thank you.
Thanks very much, Fiona. And I would also like to thank all of you for attending. The interest has been inspiring and overwhelming. In fact, it's great to see this level of interest in such an important guideline. As Fiona has said, the focus of today's webinar is presentations by our three expert guest speakers, Dr Suzanne O'Rourke, retired Sheriff David Mackey, and Kirsty Giles. They're each going to speak about one of what we consider to be the guideline's three key themes: maturity, rehabilitation, and the need for an individualised approach to the sentencing of a young person, taking into account, amongst other things, the impact of trauma and adversity in childhood. But before I introduce our speakers, I briefly want to set out some background. The Scottish Sentencing Council is an independent advisory body which was established in 2015 with three statutory objectives. Firstly, to promote consistency in sentencing practice. Secondly, to assist the development of policy in relation to sentencing. and equally importantly, to promote greater awareness and understanding of sentencing policy and practice. Its functions include preparing sentencing guidelines for the Scottish courts, publishing guideline judgments issued by the Scottish courts, and publishing information about sentences imposed by the courts. The Council's initial focus has been the creation of a suite of 3 general sentencing guidelines that will apply to all offences and form a framework for all sentencing decisions in Scotland. They will also be the foundation for future guidelines on specific offences. The first 2 of these general guidelines on the principles and purposes of sentencing and the sentencing process are currently in force. The Principles and Purposes of Sentencing Guideline sets out the core principle that sentences in Scotland must be fair and proportionate, and the purposes that a sentence may seek to achieve include, in no particular order, protection of the public, punishment, rehabilitation of offenders or those who offend, giving those who offend the opportunity to make amends, and expressing disapproval of behaviour involved in offending. The Sentencing Process Guideline sets out an 8-step process explaining how courts arrive at sentencing decisions and the factors which may be taken into account. This includes how courts should assess the seriousness of an offence with regard to the culpability of the person who's offended and the harm caused, including the impact on any victim or victims. Both of these guidelines apply to the sentencing of young people and must therefore be read alongside the subject of today's event, the Sentencing Young People Guideline, which comes into effect on the 26th of January, as Fiona has said, which is just the middle of next week. As a general guideline, it too applies to all offences, but only where the person being sentenced is under the age of 25 at the date of their conviction. It was developed over an intensive period of stakeholder engagement and research, culminating in a full public consultation in 2020 and its approval by the High Court on 9th November of 2021. I think it is fair to say that the guideline has generally received a very positive reaction since the Council published its report on the consultation exercise. But one of the things the consultation revealed is that the rationale for and legal frameworks surrounding the guideline were not always well understood by individual respondents. Aspects of the guideline have also been considered controversial in certain quarters. Today's event is therefore part of the Council's efforts to raise awareness and understanding of the guideline in furtherance of the statutory objective I mentioned earlier. Perhaps the most contentious and least understood part of the guideline for many individual consultation respondents concerns the definition of a young person as someone who's under 25 at the date of a plea or finding of guilt. Now, the Council takes an evidence-based approach to the development of all its guidelines, and it decided on this definition on the basis of a systematic review of the current neurological, neuropsychological, and psychological evidence on the development of cognitive maturity in young people, which was carried out on its behalf by the University of Edinburgh, to whom we express our thanks. I'm therefore delighted to be joined by one of the co-authors of that review, Dr Suzanne O'Rourke, who's going to discuss the review's key findings. Suzanne is a senior lecturer in forensic clinical psychology at the University of Edinburgh. With an undergraduate degree in psychology and a PhD in clinical neurosciences, Suzanne subsequently undertook her doctoral training in clinical psychology in Edinburgh. Post-qualification, Suzanne has divided her time between the State Hospital at Carstairs, leading their neuropsychology assessment and rehabilitation service, and also the University of Edinburgh's clinical psychology doctoral programme. After many years of being split equally between the two roles, Suzanne has recently moved to be primarily based at the university, although she continues to contribute to the State Hospital 1 day a week as a consultant in forensic, clinical and neuropsychology. And with that, Suzanne, I'll mute myself and hand over to you. Thank you.
Thanks, John. Just give me 1 second to share my screen with everyone. Okay, John, can you confirm that you can see that okay? Please say yes.
On my screen, I can't see.
Okay, that's not helpful. You can't see my slides. Oh, wait a sec. Now can you see my slides?
Yes, I can now. Yep.
Right, missed a step in the process. Thank you.
No problem.
1 second. I'm just trying to change my settings so that I can see you. Not to wait. Okay. Thank you very much indeed, John. Can I start by thanking the Scottish Sentencing Council and CYCJ for inviting me to present the results of our commissioned review, the development of cognitive and emotional maturity in adolescence and its relevance in judicial contexts. I would also like to take this opportunity to thank my fellow authors as listed here. My task today is to convey the key points of a substantial report in only 15 minutes, so apologies if this feels a whistle-stop tour of the key points. To make the content more accessible in the short time we have, I will also be taking quite a light touch with the neuroscience and omit an evaluation of the literature, instead directing those of you who would like more information on the full report, the link for which I believe is already in the chat. So let's begin with what actually happens to the brain during typical adolescent development. Starting with the onset of puberty, adolescence is marked by a period of neuronal pruning, where those connections that are no longer used are removed. This pruning makes way for the building and strengthening of existing neurocircuitry, thereby increasing connectivity, a process facilitated by increased myelination. It is this plasticity that allows the neuronal changes that take place during the acquisition of new skills. In this figure, illustrating the brain from above and the side, you can see that changes in the density of grey matter from the age of 5 to 20 years, with greater maturity represented by increasing blue and purple areas. You will also notice that at the age of 20, much of the brain remains green, illustrating that it is yet to fully mature. Of particular relevance is that maturation, broadly speaking, starts in the posterior regions and works forward to the anterior, the front of the brain. So when we consider cognitive and emotional maturity in the context of criminal justice, I think it's important to take some time to consider what we actually mean by that. I would suggest that being mature involves the ability to plan pro-social, goal-directed behaviours and to alter plans when appropriate. So, for example, deciding that you'd like a job, that's your goal, identifying the necessary steps towards that goal, but being flexible enough to apply for another post if unsuccessful initially. It's also important that you can regulate emotional responses, for example, keeping calm when someone spills your drink, and that you're able to consider the consequences of your behaviour. You need to be able to inhibit inappropriate impulses, so not throwing that first punch, for example, and also to inhibit your appetite for sensation seeking, making the measured rather than the risky decision and choosing not to steal a car, for example. And of course, paying attention when it's important. All of these factors have one thing in common. They are considered executive functions and they are localized in the brain's frontal lobes. Returning to our earlier figure, I've highlighted the frontal lobes, which illustrate that this is in fact the last area of the brain to mature, with patches of immaturity evident even at the age of 20, as shown in the green bit. The frontal lobes are best considered the brain's management system, coordinating and directing its other functions. For example, fully developed frontal lobes allow you to direct, sustain, and switch attention, excuse me, to solve problems, plan and strategize, organize your thoughts, and consider multiple streams of information simultaneously. They regulate intense emotions and control your impulses, inhibiting inappropriate behavior and considering its consequences. They allow you to adjust your behavior or shift strategies in changing scenarios or situations, and to negotiate the balance between short-term rewards and long-term goals. So I've decided what we might consider the relevant aspects of cognitive and emotional maturity in adolescence, but what about the behaviours we might consider problematic? The APA describes adolescence as a period typified by volatile emotions and boundary testing behaviour as individuals explore and assert their personal identity, learn to navigate peer relationships, and transition to independence. Of most relevance to criminal justice are the biological drivers towards increased reward and novelty or sensation seeking, particularly in the context of peer influence. Excuse me. Measures of sensation seeking are often predictive of risk-taking behaviour, such as drug taking, offending, or more pro-socially, an interest in extreme sports. There is a consensus that sensation and reward seeking peaks in adolescence before reducing in adulthood. Sensitivity to incentives or rewards may be highest between the ages of 14 and 16, albeit that's debated, creating a differential bias to those goals based on short rather than long-term rewards. In turn, impaired decision-making capacity can lead to higher risk strategies in the pursuit of these goals. The presence of peers further increases these risk-taking behaviours evidenced in studies of driving and drug use, but peers can also exert a pro-social influence, diverting adolescents from poor choices. It may be that adolescents experience greater emotional arousal in the presence of their peers, increasing their sensitivity to rewards, while also perhaps further attenuating their sensitivity to aversive stimuli. Alternatively, it may be that adolescents are hypersensitive to possible social exclusion or rejection, with the fear of these potentially outweighing more important risks, such as health, safety, and legal censure. Returning to our earlier illustration, I circled here in black the regions which process social and emotional information, allowing adolescents to experience increased arousal, emotional intensity, and sensitivity to social influence. Recalling my earlier point that the brain matures in a posterior-anterior direction, you can see that there's a discrepancy in the maturing of this socio-emotional system and the executive functions situated in the prefrontal cortex. This heightens the attraction of adolescents to exciting, high-risk activities at a time when the cognitive control system, which is slower to mature, is not yet developed sufficiently to successfully or consistently restrain these urges, resulting in the discrepancy thought responsible for the behaviours that typify adolescence. As the cognitive control system continues to mature, self-regulation of behaviour increases, which in turn decreases reward seeking. In order to make mature decisions, both the cognitive control and the socio-emotional systems need to be coordinated. Before this occurs, those in the middle of adolescence are left exposed to increased risk-taking behaviours. Thus far, I've described what we would consider typical adolescent development. Sadly, we know that particularly in criminal justice populations, brain development doesn't always follow a typical course. I've listed here some key mechanisms that may interfere with cognitive and emotional maturation, along with estimates of their prevalence in both the wider and prison populations. Do remember that estimates depend on diagnostic assessments taking place, so may represent underestimates, and that definitions of each condition vary, so the figures here should only be considered indicative. Importantly, we have clear evidence that each of these factors results in structural or functional differences in the brain, resulting potentially in lifelong cognitive impairment. This means that today's discussion will also apply to many of the adults you work with. Unfortunately, I don't have time to cover all of these today, so instead I'll focus on those that where you may be less familiar with their impact on brain maturation: adverse childhood experiences and fetal alcohol spectrum disorder. Childhood maltreatment mostly occurs in an interpersonal context and can include physical, sexual, or emotional abuse, as well as neglect. Young people are dependent on their caregivers for safety and love, creating attachment security and a safe haven from which to explore and develop. Attachment security promotes positive psychological development, especially in regards to social and interpersonal competencies, but also the capacity of mentalization, emotional regulation, and associated neurocognitive functions. Neuroimaging research indicates that deviation from this model significantly impacts the development of brain regions underlying social information processing. The most consistent finding in those who suffered abuse is structural abnormalities in the corpus callosum, the connective pathway between the brain's hemispheres responsible for our ability to integrate sensory, motor, and cognitive functions. According to the latent vulnerability theory illustrated here, maltreatment brings about quantifiable changes in several neurobiological systems that reflect a functional response to the adverse early environment. A central principle of this theory is that those alterations are adaptive. They benefit the individual in the context of the early maladaptive environment. For example, hypervigilance may be adaptive in an abusive household, despite the potential negative long-term effects of the stress hormone cortisol. Essentially, in order to survive in adverse environments, the brain develops altered threat and reward processing, altered emotional regulation, and executive control. There's now a substantial body of evidence, including from neuroimaging, to suggest that childhood maltreatment alters the brain's executive functioning, including the processing of threat and rewards and the ability to regulate emotions. Specific weaknesses are observed in inhibitory control, cognitive flexibility, sustained attention, visual auditory attention, working memory, planning, and problem solving. Notably, certain executive functioning deficits have been associated with specific types of maltreatment. For example, physical abuse has been linked to problem-solving deficits, while sexual abuse has been linked with cognitive flexibility and problem-solving difficulties. Emotional abuse has been associated with impairments in attention and working memory. Moreover, the overall severity and presence of chronic maltreatment has been associated with the degree of executive functioning deficits, perhaps suggestive of a dose-response relationship. Fetal alcohol spectrum disorder, or FASD, describes symptoms resulting from brain damage incurred by the developing fetus due to prenatal alcohol exposure. Evidenced in a broad range of motor, sensory, and cognitive impairments from an early age, difficulties can become more apparent in adolescence as the structural and functional brain differences associated with the condition impede the typical process of maturation. In the UK, awareness of FASD has been limited, with few services offering diagnosis, with the consequent lack of support leading to secondary harms, including contact with the criminal justice system and susceptibility to drug and alcohol abuse. It is in affected individuals' poor decision-making, difficulty learning from past experiences and understanding the consequences of their actions, along with their being easily led and prone to confabulation, that may bring those affected into contact with the legal profession. In the absence of a diagnosis, the issue is rarely identified by the legal system, given that 80% of those affected do not have an intellectual disability and 90% do not display the facial features that can be associated with the condition. Additionally, individuals can be comparatively strong at verbal communication, often masking significant difficulties with executive functioning and social interaction. Based on North American figures, the minimum prevalence in the UK's wider population is likely to be a minimum of 1 in 20, with far higher rates in vulnerable populations. Indeed, a recent study of meconium in an unselected samples of newborns in a Glasgow maternity hospital indicated that 40% were exposed to alcohol during the second half of pregnancy, and that 15%, so 1 in 7, had results indicative of exposure to frequent binge levels of alcohol, placing them at high risk of FASD. While no data currently exists for the proportion of UK offenders who may be affected, case ascertainment studies, so where researchers have proactively assessed populations rather than relying on existing diagnoses from Canada and Australia, suggest figures may be as high as 1/3 or half of all prisoners. Indeed, such is the recognition of the disorder in Canada that they have introduced specialist courts for those with the condition. I can assure you that you will be hearing more about FASD as awareness grows in the next few years. So forgive me, I appear to have lost my conclusions here. So I'm going to have to ad-lib. In conclusion, I think the important take-home message is that typical development takes until 25 to 30 years, that many individuals fail to achieve typical development. They fail to achieve what we would consider full maturation. And that as a result, it's very important that all of those of us working in criminal justice settings bear that in mind and consider the presence of potential cognitive impairments, not just in young people, but later in life as well. And that we take that into account in terms of the way we interact with young people and in the way that we deal with them in our courts. And apologies for failing to have, I have no idea what happened to my conclusions. I shall hand you over back to John while I think what went wrong there. Thank you.
Thanks very much, Suzanne. That was such perfect ad-libbing that I fully expected after you finished the exact same words were going to appear on the screen. We've been asked if slides will be shared later, and I think that's been agreed. So
you'll see my conclusions there.
Perfect. But thank you very much, Suzanne. And it's so interesting and helpful to see some of the science behind the people that we may deal with, whether we're social workers or lawyers or sentencers or in many different aspects, and to see what lies behind some of what we will experience with them. Reflecting the evidence in cognitive development, which Suzanne has been discussing with us, the guideline says that a young person will generally have a lower level of maturity and a greater capacity for change and rehabilitation than an older person. For this reason, it states that rehabilitation should be a primary consideration when sentencing a young person. Now, this doesn't mean that other purposes of sentencing, such as protection of the public, don't apply. However, the Council believes that courts should give additional weight to rehabilitation when selecting a sentence in order to help young people move away from offending. Our next guest speaker is someone who's known for putting that rehabilitative approach into practice during his time as a sheriff. David Mackey is a graduate of the University of Edinburgh and was in private practice as a solicitor and then an advocate for some 25 years before being appointed a sheriff in 2001. For 15 years then, until his retirement from the bench in 2019, he sat as the resident sheriff in Alloa, where he dispensed enlightened justice. And I'm pleased to say that David continues to sit on the bench on a part-time basis. Through his work as a sheriff and with charities supporting disadvantaged and marginalised young people, David developed a belief in the power of redemption and applied compassion and understanding. Pardon me. Applied compassion and understanding of both the victims and perpetrators of crime to his personal judicial practice. In August last year, David was appointed as the independent chair of the Hearing System Working Group, which is looking at a redesign of the children's hearing system. And the synergy with some of the other work that you're hearing about is quite striking. And then lastly, David has just recently taken over as convener of the Howard League for Penal Reform in Scotland, which is a position that I held for a while. So delighted to have David along, and I'll mute myself now and hand over to you, David.
Well, thank you, John. And thank you, Suzanne, for that fascinating introduction to the science behind some of the effects that we experience in the system. And I must say, I found it personally quite affirming, which might be reflected in what I'm going to be saying to you just now. I speak to you as a practitioner, a judicial practitioner within the criminal justice system in Scotland. I don't pretend any particular expertise, knowledge, or understanding that other Shrivel and judicial colleagues do not possess. Quite the contrary. And especially, I do not suggest that any views I express have any greater legitimacy than those of other practitioners within the criminal justice field. But in my own journey to understanding why people commit offences and come into conflict with the law, I came to understand that the things that help a person desist from offending or an offending lifestyle are commonly the apparently mundane, a strong partner or relationship, a family, a settled and safe home, good employment. And so the solutions to helping a person achieve desistance seemed counterintuitive when society's instinct is to start with retribution and punishment. It wasn't difficult to reach these views. We've known for a long time that short custodial sentences do more harm than good and do nothing to help people who have come into conflict with the law, especially those who have experienced trauma, adverse childhood experiences, addiction, and mental health problems. For example, this was recognized in the report of the Angelini Commission back in 2012, but it was understood long before that. I can think of research I came across in the late 90s, early 2000s. But this understanding has informed policy to the point that we now have a presumption against sentences of imprisonment under 12 months. In other words, a presumption against custody for any crime prosecuted at summary level. I have no statistics to offer, but my personal sense is that the majority of those who've appeared in front of me over the years have indeed been young people, 25 years of age or under. And so often one's hope was to help a young person find the right road in life and become a positive contributor to the community in which they lived and not a burden. In fact, I came to see my role as a sheriff as one of helping young people in particular get out of the criminal justice system, because it was a horrible way of sucking people in and not letting them go without a considerable effort. So I congratulate the Scottish Sentencing Council on their publication of these excellent guidelines for the sentencing of young people, for putting unequivocally in writing that a young person is someone under 25 years of age, and for backing that up with 100 pages of research that Suzanne's touched on briefly this afternoon, for recognizing that the human brain does not reach maturity, and nor do people until their mid-20s, and for directing us to take that into account in the sentencing of young people. I congratulate them for the focus on community-based disposals, the acknowledgement of the impact of trauma and adverse childhood experiences, addiction and mental health problems, and the exhortation to sentencing sheriffs and judges to make use of the facility of review hearings in their engagement with people on community-based orders. The mechanism of achieving rehabilitative sentencing has been with us for a number of years, and it is the community payback order. Before that, probation orders and community service orders, but now the community payback order. And I probably don't have to say too much to this audience about what a community payback order is. I'll simply explain that it is the primary order, the primary vehicle by which a sheriff can impose a community-based order at the point of sentence. It is an order that can contain a number of components, commonly, for example, a period of supervision by a criminal justice social worker for up to 3 years, perhaps unpaid work. It might include a specific program depending upon the availability of services in the area to address, say, domestic violence, sexual offending, or drug or alcohol use. So the mechanics of community-based disposals are quite simple and straightforward. And if a person fails to adhere to the order, breaches it, there can be adverse consequences, including the imposition of the custodial sentence that was avoided the first time round. All bets are technically off if that happens. So what is it, though, that makes a community payback order work? What is it that will lead to a successful outcome? There are many factors. But I'm going to focus on two essential elements which I've identified as contributing to the success or failure of a community payback order. And they both revolve around the person who was key to the order, the criminal justice social worker. A sheriff cannot reach a decision on a community-based order on their own. They need the advice and guidance to be found in the criminal justice social work report prepared by the social worker. In my early days as a sheriff some 20 years ago, I encountered a range of attitudes among my Shrieval colleagues towards this branch of the social work profession, ranging from tolerance to contempt, but rarely admiration or respect. Some colleagues refused to engage with social workers and were offended at recommendations from them about possible sentencing solutions as an assault on their judicial independence. I'm glad to say that attitudes have changed markedly over the years, but defensive attitudes about supposed judicial independence still prevail and can, in my view, impede the success of the sentencing process, and I'll come back to this later. the report, the Criminal Justice Social Work report, really matters. It is prepared by someone who has studied and trained in the field and who is by any measure an expert. It provides important information and insights into the personality and background of the person who is the subject of the report, and most importantly, includes a risk assessment carried out in accordance with well-established psychological tools which the author is trained in, to offer some insight to the likelihood of a further offending and the nature of possible further offending by the individual, especially if that does or does not represent a danger to the public or to intimate partners and family. The reports really matter, and they do inform decisions made on the bench. Now, it might be naive to suggest that criminal justice social work reports are universally of the highest quality and always provide the insights sought by the sentencing sheriff or judge. Some social workers are better than others. Some have more experience. Many have unrealistic workloads and cannot devote the time and attention they would like to the preparation of their reports. And that variation in quality is a pity, because it can fuel a certain skepticism that does exist around the role of criminal justice social workers and their reports. That wasn't my experience. In Alloa, where I was the resident sheriff for a long number of years, I was the beneficiary of a fine team of criminal justice social workers whom I regarded as my experts, my consultants, and my advisors on community-based sentences. I got to know them individually, and I took opportunities when they were at court to chat about their work or interesting talks I'd been to at SASO or of developments in the field. We used to have regular meetings to discuss local issues and developments. I let them know that their reports affected my decision-making and invited them to offer their recommendations about how to deal with the individuals who were the subjects of the reports. They knew that I might not follow their recommendations because I disagreed or because I thought that in an individual case, the offending was such that the disposal should contain a greater element of retribution, an aspect that was beyond the scope of the social worker's input and very much the realm of the sheriff. But very often I found their recommendations to be well-reasoned and appropriate, and I followed them. But the reports had another valuable contribution to make, and that was that it enriched discussions with solicitors on appropriate sentencing decisions, because their advocacy in court was important too. And that's a whole other section, is one of the many factors that, that are relevant to all of this that I'm not going to have time to go into, but we must never undervalue the importance of advocacy in all of this. My experience was that by giving the social workers the responsibility I've described, they rose to the occasion and consistently delivered reports of the highest quality. The second element is less tangible, but in my view, perhaps the most important, and it can be summed up in one word: relationships. The success or failure of a community payback order depends hugely on the relationship between the person who is the subject of the order and the social worker. Of course, it is desirable to have good programs, facilities, and opportunities for people on orders, connections with potential employers, and training. And we need good investment in all of that. But if the relationship between the person on the order and the social worker is not good, the prospects of success diminish. Some people are determined to get out of the system and they stick with it come what may, but the more vulnerable, marginalized, traumatized individuals who so often end up in the system will struggle. So again, so much rests upon the criminal justice social worker and their relationship with the person on the order. It goes without saying that if the social worker has to change for organizational reasons or for absence through illness or because they're moving on in their careers, that can act as a backward step sometimes in the progress of an order. But the relationship with the sheriff can make a difference too. And how can that come about, you might ask? In the late 90s, there arrived in Scotland the Drug Treatment and Testing Order, the DTTO, and we still have it. It's a kind of expert relative of the Community Payback Order. It's a specialist community-based order with drug treatment at its heart, but a key component to its success was found to be the regular reviews by the sentencing judge, in Scotland, the sheriff usually. The reviews were commonly monthly for a period of 2 years, and that engagement, and dare I say it, relationship with the judge was found to make a difference to the effectiveness of the order. That notion was developed in youth court pilots in Hamilton and Airdrie and began to be utilised in relation to the former probation orders that we had. Now, a sheriff can order review hearings in relation to community payback orders and has a very free hand in how they can be conducted. In my practice, I realised that often the things that made people struggle on their orders were very private and hard to talk about in open court. So I devised a practice of conducting community payback order reviews, dressed down as I am in a suit, not my wig and gown on, in private. We happened to do it in the jury room in Alloa, which was conveniently located next door to the court and next door to my study, my chambers. I organised it procedurally so that the procurator fiscal did not need to be in attendance, and I did that by isolating review hearings from any other deferred sentences that the individual might have. And so the only people in attendance were me, the person on the order, the social worker or a social worker, if it wasn't the person's individual social worker who could be available, and the solicitor, who played very little part in the proceedings. This arrangement created a good environment for a conversation between me and the person on the order. The feedback from social workers was that it made a huge and positive difference to the individuals on the orders who appreciated the personal interest shown by the sheriff. They developed a desire not to let the sheriff down and to have good news at each review. And in my experience over the years in Alloa, the review hearings became an important component to the success of community payback orders. And so I'm glad that in its guidance, the Council has specifically made reference to their use. Some sheriffs balk at the idea of having a relationship with an offender beyond their formal judicial role, and as with the engagement with social workers, regard it as an incursion upon their judicial independence. I personally think such concerns are misplaced. At the heart of the notion of judicial independence is the concept of bias or the perception of bias. Professor Cyrus Tata, in his recent book, Sentencing a Social Process, and to any practitioners listening in this evening, I recommend the book. It's quite a heavy read in the first few chapters, but the last two chapters bring it all together in a fascinating discussion on this subject. But Cyrus Tata coined the phrase autonomous individualism, that notion of the well-intentioned, public-spirited judicial officer with a strong sense of duty and of bearing the sole responsibility for making an important decision. In the end, he concludes that it is a positive feature, but not before characterizing it as partly proprietorial and something of an impediment to the implementation of public policy in relation to sentencing and also research on sentencing. And in relation to judicial independence, I commend an article by Fiona Jameson, which she wrote in 2018. She's a senior teaching fellow at the University of Edinburgh, formerly a procurator fiscal, and I think she used to practice in Falkirk a number of years ago. And the article is entitled Judicial Independence, the Master Narrative. And in this, she challenges the strict adherence to what is known generally as the Olympian notion of strict judicial independence within a penal setting. The point is that up to the stage of a finding of guilt or innocence, the sheriff or judge must be totally independent and insulated from influences that are not relevant to the case in order to avoid bias or the perception of bias in reaching a decision. After that, in the event of conviction and during the sentencing process, because it is very much a process and not an event, the requirement for such protection diminishes, and a greater benefit may be derived from a collaborative and inclusive approach being adopted by the sentencing judge. Because as I said earlier, in most cases, a sheriff, a judge can't do the sentencing entirely on their own. They need input from advisors like social workers. They need the advocacy of solicitors and advocates representing parties in court. I have a dozen anecdotes about people I've met at community payback order review hearings and remarkable things that have occurred there. But I'm going to close with just one, which in a sense captures much of what I've just said, but also what we've heard from Suzanne. A great way to get people to open up is to ask very open questions. And one I used to ask was this: don't answer the question, but I want you to think where you'd want to be in 5 years. Do you want to be back here facing your 50th conviction and enduring the hassle of the criminal justice system? Or would you want to leave that behind you? Perhaps you have a good job, you're settled in a relationship, maybe you've started a family, you have a nice secure home, maybe a car, and perhaps you're able to take a holiday abroad each year. And by this time, the people are usually nodding their head in agreement. Now, I know it's a bit corny, but then I would say, well, if that's the destination, how did you get there? You got out of the criminal justice system, you probably went to college and got some kind of qualification, you got a job, and so forth. And so I ended, if that's the destination, well, that journey can start right here when you walk out of this room. Now, it is a bit corny, but it used to have some impact. And there was one day I was walking across to the post office in Alloa. A car pulled up beside me. 4 guys jumped out. They were just being dropped off after work. And one of them said, "Oh, Sheriff Mackey, hello, how you doing?" And I turned around, and it was a young man who about 18 months or a couple of years beforehand had never been out of my court. And that was for a period of a year or more. He was appearing regularly, almost on a weekly basis, with public disorder offences, fighting, minor drug offences. And he was the kind of guy that you felt his life was just going down a plug hole because he was completely on the wrong road. But he was on a community payback order, and we had that conversation. I asked him how he was doing, and he said, "I've got a job, Sheriff Mackey." And he had a job at the glassworks. He was sorting broken glass on a conveyor belt, but he told me that in three months' time, they were going to put him on the machines as a machine operator, and that was a great job. And this was a 6-week trial he got 6 months beforehand. So I said, "Well done, that's fantastic, and thanks for letting me know about that." And I went to move on. But he stayed with me. And he said, "Sheriff Mackey, I'm going on holiday. I'm taking the wife and Waynes to Paris, Disneyland, Paris, a week on Saturday." And he knew the significance of what he was saying to me about that. And as we say in the west of Scotland, I could have gret. But right there in that real example is everything that I think we've talked about, everything Suzanne has talked about. And when I said to him, "Thank you for letting me know that, that's wonderful," he left me with a cheery wave and said, "Oh, Sheriff Mackey, you stood me in good stead. I'd never pass you." And if you're ever looking for a reward in your work, you find it in things like that. Thank you very much.
David, thank you. Please have a look at the chat. Your contribution this evening has gone down very well, including from someone who worked in social work and worked with the young people in your sheriffdom, who says they're still talking about you. I think most of us, when we hear that, would probably be worried about it, but I don't think in your case you need to. Yeah, please have a look at the chat. It's fantastic.
I still miss them all dearly. And I miss my Thursday afternoon chats with the people.
And we've got a brilliant crowd here. I mean, there's 367 people in at the moment, and people are answering their questions themselves. So there's things that come up about Cyrus's book, and so thank you to everyone for helping us with that. We've got a couple of questions in the question and answer function, which we'll come to after Kirsty. But if there's any other questions, please put them in the question and answer function just now. It might be that we run out of time today, but we'll try and get back to you with anything that isn't covered. So yeah, thanks again very much, David. The issues highlighted by both Suzanne and David underpin the provision in the guideline requiring the court to ensure that it has sufficient information to assess the maturity of the young person and to identify and impose the most appropriate sentence. The guideline goes on to say that this might include information about a number of things such as physical and mental health or speech, language and communication needs. Of particular relevance is the need for courts to obtain information where appropriate on trauma and adverse childhood experiences due to the impact we know such experiences can have on brain development and behaviour, and we heard that from Suzanne earlier. Our final speaker today is Kirsty Giles, who has extensive professional experience in addressing these issues in a criminal justice context with a view to preventing reoffending. Kirsty is a psychotherapist specialising in children and young people, a trainer and a project manager working across Scotland to reduce violence within the Scottish Violence Reduction Unit. Kirsty is also a member of the Trauma Aware Law Team, who work to improve the justice system for both the staff and the clients involved. I should say that they also work with the legal profession to do that. And I was a beneficiary of Kirsty as one of the course organisers for the very first course run by the Law Society of Scotland to produce 20 certified specialists in trauma-informed practice. So I'm very proud to be one of that first group of 20, and thanks to Kirsty for guiding us through that. And then lastly, but not least, Kirsty is a mentor for the Inspiring Women in Leadership project in Scotland. So as before, I'll mute myself now and over to you, Kirsty.
Thank you very much, John. How to follow Dr Suzanne O'Rourke and Sheriff David Mackey, but I will try my very best. I'm just going to share my screen and check that everybody can see this.
We've got it, yeah. Thanks, Kirsty.
Okay, great. I'm going to talk about individualised approaches, and I'm hoping to tie in with a bit of what Suzanne and David said. And I'm going to specialise, just as John said, on adverse childhood experiences and childhood trauma. For me, the most important paragraph of the whole guideline is this one. Rehabilitation is a primary consideration when sentencing a young person. When selecting a sentence, the court should, where appropriate, seek to rehabilitate the young person and to reduce the risk of reoffending. So I'm going to focus on that for the rest of my time. So what does this mean in terms of people that we see in the criminal justice system? And that's people that I work with as a psychotherapist and people that come through the Violence Reduction Unit. Suzanne and our colleagues touched upon this in the research, and if you haven't read it, please do. It's an incredible piece of work. What we need as children is attachment. We are innately driven to attach, and this slide shows us that what that means is a circle of security. It's a secure base and a safe haven. And what it says in the bottom right is we need people that will be bigger, stronger, wiser, and kind. And if we don't have that, which is the young people that we're talking about, the vast majority of them that come into the criminal justice system, if we don't get it from what we're told in the movies, from your 2.4 stereotypical nuclear family, the beautiful mum and dad and beautiful children, young people will have to seek it elsewhere. And what we know is where they seek and find it is here. It's in gangs. So my colleague and friend Ian Smith often says, see a child differently, see a different child. Young people are seeking attachment in gangs. And if we can start to become really curious about what that means and what that means for the criminal justice system, instead of judging and shaming it, which is what the system does at the moment, we will start to see different children and young people. So I'm going to take you through some case studies because I think it's important to look at this from an individualised approach. So I'm going to talk about Peter, who's 18. As Suzanne pointed out, this image is showing that Peter has had adverse childhood experiences and childhood trauma, and therefore his brain is not functioning the same way that someone that hasn't experienced those would. Peter's academic, he's clever, and when he does get to engage in school, he's very good at it, and that's really important. However, this looks like a house, but it's actually a doghouse. Peter has a very difficult time at home. There's a lot of abuse that goes on in the house, a lot of substance misuse and domestic abuse. Due to this, as I've just talked about, Peter seeks attachment elsewhere in the form of a gang. And what happens when young people seek attachment in the form of a gang is they orientate to other peers who again have a similar level of trauma and brain difficulty and are not the correct peers, are not mature enough to orientate into positive role models. So what tends to happen here? They all get involved in violence. Peter then drinks alcohol, and what we know about the link between trauma and addiction is that Alcohol and drugs are an attempt at a solution. And the reason they are is because they work. Weed is an analgesic. Alcohol gives you confidence. People do these things because they're successful in the short term. Peter then starts to steal cars. His friends are stealing cars. What's really important about Peter is that he's got a great relationship with his gran. He's got a wonderful connection with her. Just as Sheriff Mackey talked about, there is one really strong relationship in Peter's life, and that's important to recognise. Moving on to Lucy. Lucy's 24. Again, Lucy's experienced difficulties in her early childhood. Lucy had a baby, and the baby was taken off Lucy. This was due to a domestic abuse relationship, so a very horrific events in Lucy's life, and she was deemed as to no longer be able to take care of her child. Because of this, the pain that this causes, Lucy turned to substances. In order to be able to cater that habit, Lucy starts to steal from houses. She needs to get money to feed a habit, and she starts to carry a knife because she's afraid of her ex-partner and she's afraid of what might happen to her. Just the same as Peter, Lucy gets charged and she becomes part of the criminal justice system. And lastly, we'll talk about Danny. Danny's 23. Again, similar difficulties in childhood leading to difficulties with brain function. Danny joined the army, and we see this a lot with young people that get caught up in the cycle of violence and criminal justice. From the army, Danny came back with complex PTSD. And in order to try and cure the symptoms of that, which can be very horrific for young people, Danny turned to drugs. He got involved in violence in order to cater for his habit. What's important about Danny is Danny's got a very loving relationship with his partner. We need to make sure that we're making key indicators of the resilience factors here. What else is interesting about Danny? Danny's really fit and healthy, and this is something that we can harness. But again, Danny gets caught up in the criminal justice cycle because of his offences, and he's involved in the system that we have at the moment. So here's 3 examples of individual differences that can happen, and I'm sure you'll all have seen cases like this or something similar. What's important to notice is they've all experienced addiction. We cannot separate it. In the VRU, we believe that if we were able to treat adverse childhood experiences, we would halve addiction and we would eradicate violence. I've worked in Berlin, I've worked in Stockton. I've never met anyone in these prisons that were not under the influence of something when they were involved in criminal activity. We have to make sure that we take addiction very seriously and we recognise that this is a treatment for pain. So what does rehabilitation look like? What does it look like on a wide scale before we go back to the individuals? Sheriff Mackey talked about it. It looks like healthy relationships. Healthy relationships with healthy boundaries. And this is the opposite of what these young people have ever had. The system, their parents, their family have not been healthy relationships and haven't had healthy boundaries. What we know work from the VRU is a mentor who, what we would term, has lived experience. But for me, a lived experience mentor simply means hope. And Sheriff Mackey talked about that too. We have people called navigators, and we have them in communities and we have them in custody suites. And we're in conversations about what this would look like in a court setting. So a court connector. What would it look like if criminal justice social workers had somebody that they could refer to where these young people could work with someone who's got lived experience? There's some amazing examples of this that already go on, but we would like to put someone directly into the court. The difficulty with it is it couldn't be court mandated. So although we would want this person to help a young person to adhere to their community payback order, we believe that lived experience mentors are the key and would also help some of the stress of the frontline workers that are dealing with high caseloads and a lot of trauma. And what else do they need? Well, they need a healthy dose of hope, and they need a system that believes that they can change, and they need more research from people like Suzanne and more sheriffs like Sheriff Mackey. Peter, Lucy and Danny all need this. And what does it really look like? What is a healthy relationship? It's not letting someone away with bad behaviour. It's not saying yes all the time. It's boundaried. It's about trust. It's about compromise and communication. shared values, commitment, and respect. And this is something that I think we lack in our criminal justice system. In order to demand respect from someone, you have to first show it. And if we can't respect young people, because actually in my experience, these young people are some of the bravest and most resilient young people we have in this country. To live a life where your house isn't safe and there's no food in the fridge and you look after your siblings and you're beaten instead of brought up, to survive that is the definition of resilience. And if we can just harness some of that and help young people to recognise that there is hope, that they can change. And now we know the science, that the brain is malleable, but we have to look after these young people at a pivotal point where we can help them and support them into a different way of life. So let's go back to these individual cases and think about what it means for all three of them. What I've done here is I've used yellow to show you the individualised motivators and resilient factors which would rehabilitate and reduce reoffending. For Peter, he's clever. Harness that. Peter could go to college. Peter could run a business. If you're working with someone who is academic, please see that as a resilient factor. And Peter has a great relationship with his gran. That's really important for us to know. The strength of relationships around Peter will be one of the key things that help him to change. For Lucy, I've never worked with any female that, if they've had their children taken off them, the single best motivator for a different life is access to their children. And I know that's not always possible, and I know social work by and large do the best they can. But if we can increase visits, or we can make visits easier or safer, that's how we're going to help Lucy to change. That's how we're going to help reduce her addiction. And what we think about with Danny's got a great partner. We need to harness that. We need to bring Danny's partner into the picture. What can Danny's partner do to help us as professionals? Because I can assure you Danny will listen to her more than he'll listen to anybody else. And Danny's fit and active. And Suzanne talked about the risk-taking behaviours. One of the things that a court connector might be able to do is a preventative approach. So before a young person becomes part of the criminal justice system and in court, we could look at sentences whereby maybe they get involved with venture trust and they're able to challenge that part of the brain that deals with risk-taking behaviours in safe risk-taking ways, instead of stealing cars, instead of taking drugs. We have to use this science to our advantage. We can't ignore it anymore. So the risk factors, what do we know about Peter? Peter comes from a really difficult home. Peter's parents didn't know how to love him because nobody taught them. And not knowing how to love someone is different than saying Peter's parents didn't love him. Because if we want to get into the blame and shame game, we're going to have to look at Peter's parents' parents and their parents' parents and what we call intergenerational trauma. So we have to move away from blame and shame, and we have to move into compassion and understanding. And if we can help Peter with that, we'll help him with his addiction, because again, a lot of the time, the addiction is to heal untreated trauma. With Lucy, the domestic abuse situation and relationship will have had a massive impact on the reasons that she takes drugs, and also the drug taking behaviour. That would be something that would require support as opposed to judgment. In Danny, complex PTSD often goes undiagnosed, or it gets diagnosed as bipolar disorder or schizophrenia. We have to get this right when we're thinking about young people in the criminal justice system. And if we were to be able to heal that, I can assure you that Danny wouldn't feel the need to take drugs. So what are some key takeaway messages from me in terms of individualised approaches? The science is clear. The guidelines are not only useful, but they are crucial. We must listen to them. We must think about rehabilitation for these young people. It's unbelievably crucial, and it's unbelievably exciting that Scotland has done this. I'm very proud to be Scottish today. We've all got a part to play in this. This isn't just about the workers in the criminal justice system. This is about reaching out to our third sector partners. It's about reaching in to families, doing family approaches. Healthy relationships are what's going to heal these young people. And what we know is that hurt people, but healed people go on to heal other people. Some of the best colleagues I have are true lived experience from trauma, addiction, prison, and they play an unbelievably crucial role in the work that we do in the VRU. And we want to make Scotland safer. We're on your side. This isn't soft justice. This isn't about letting young people off with bad behaviour. This is about making Scotland safer and helping people to heal, which I think we would all agree we want. Judges, be kinder. Be more like Sheriff Mackey. And if you can't be kinder, at least be curious. So an example would be ask questions. To someone like Peter, do you think you've got a problem with drugs and alcohol? Do you think it affects your violence? Would you be willing to address that? I'll tell you a wee bit about a personal experience for me. One of the most stressful events possibly that I've been through, you would maybe even call it a single traumatic event, happened not that long ago, just before I joined the VRU. I used to work in domestic abuse recovery, and I supported a mum and her children. And 2 years later, after I'd left that job, I was called up as a witness to court. And I was the children's worker, so I was supporting the children. And I had a chance to look over my statement. And then I was put up into the dock. And I believe, even when I think about it, I get that visceral reaction. I get very sweaty and a bit panicked. The way that I was treated by the sheriff was appalling, to the point where I almost had a panic attack on the stand. Now, I'm a psychotherapist, right? Panic attacks, I understand them. I understand the physiological response to them. I had to be taken off the stand, taken outside. I had to get some Lucozade. It's all quite embarrassing. And I couldn't go back in. And I remember it took me a few days to recover from it. And I remember thinking, geez, if that's how they treat a professional, how on earth do they treat a perpetrator? And I'm not saying that this is what happens every time there is a court process, but your words are so powerful to people, especially young people. And some of the young people in the criminal justice system have never heard anything kind in their life. So if you have an opportunity to be kind, or at least be curious, please take it, because they can probably count on the one hand the amount of times this has happened. And the people that we take for granted that are kind to us, like our parents and our siblings and our friends, these young people just a lot of the time don't have. Please always look for who's doing relationship with these young people and increase this support. It could be a family member, it could be a support worker or a social worker, it could be Melissa or Ian, trauma-aware lawyers, and now the other ones that we're training up. But please focus on that, relationships within the young person's life and other ones that you can build up, because the strength of healthy relationships is key here. We cannot separate addiction and trauma, they are too interlinked. Addiction is the coping mechanism, and it's almost often the trigger for violence or offending behaviour. Please don't see the two as separate. Have hope that we can achieve this, but it needs to be joined up, it needs to be multi-agency, and it needs to be trauma-informed. So thank you for showing up, thank you for listening, and thank you for caring about the young people in Scotland. I'll now pass back over to John.
Kirsty, that's fantastic. Thank you so much.